Members, court rise.
Thanks.
Yeah, sorry to have kept you waiting. Yes.
Just before the short adjournment, we were looking at paragraph 147 of the judgment. It contains the judge's reasoning in relation to the disclosure of Neunschwander as to whether it discloses separation between the supply device and the socket. And just to remind ourselves, that there were essentially two reasons that the judge records in 147. One, that figure 2 merely records the possibility of separation, and secondly, that the at a distance passage bridging columns 3 and 4 didn't advance matters over figure 2. So I have two criticisms in relation to the judge's reasoning there. The first is in relation to figure 2, there is no question that this is a schematic diagram. Indeed, it's described as such by Neunschwander at column 5, lines 13 to 15. What the judge seems to have thought is that if a diagram is said to be schematic, then it doesn't necessarily disclose the location of components. Now, as it happens, figures 1 and 5, which plainly disclose the relative locations of certain components, are also described as schematic, but my criticism of the judgment is more fundamental than that. And it is this, that there is no dispute, looking at figure 2, if you also wish to remind yourselves of what we're looking at in figure 2. It's on page 13. There is no dispute that there is a discontinuity in the supply lines in figure 2 between the socket and the relay activated switch. Now, there is no discontinuity in the optical conductors, 52 and 53, but Neunschwander states in terms, at column 6, lines 58 to 63, that those optical conductors extend from the receptacle to the amplifier. My Lord, the judge has simply overlooked that express disclosure of those conductors extending from the socket to the amplifier. Second criticism.
Sorry, Mr. Rackford, just forgive me.
Yeah.
Is there any point on why would one show a discontinuity in one line and not the other?
Not that was explored.
It doesn't seems odd, let's say.
There was no explanation of why that would be the case. The second criticism concerns the judge's treatment of the passage bridging columns 3 and 4. And to that end, may I show you the submission that was made to the judge in our written closings. So it's in supplementary bundle 2, tab 18. It's page 353 of the bundle, internal page 55. Can I pick it up at paragraph 281? This is under the heading Anticipation of Claim 1. 281 says, and the figure 5 embodiment clearly has the optical circuit extending out of the back of the receptacle. So we're now talking about the second embodiment. Then there is a recitation of the passage that bridges column 3 and column 4, which is set out in italics there. And you'll, I hope, by now recognise the two alternatives that are disclosed there. First of all, both the emitter and receptor being arranged within the receptacle, and alternatively, the emitter and receptor can be arranged at a distance, in which case there is a solid optical conductor. So in paragraph 282, we say, so in a first embodiment, both the emitter and or the receptor, which comprise the sensor, are arranged within the receptacle. But in the second embodiment, as shown in figure 5, they are at a distance from the barrier portion. Paragraph 283, figure 5, as coloured by Mr. Borowski, shows the optical conductors 94, 89 and 96, and over the page, at the other end of the optical barrier conductors, they have emitters or sensors, receptors, as provided in the text at column 3 quoted above. Now, if one then looks at the judgment, paragraph 146, sub 4, the judge picks up two lines, column 3, lines 66 to 68, refers to the possibility of the emitter and receptor not being within the receptacle but at a distance from the respective opposite ends of the barrier portion. But he doesn't refer to the surrounding context. In particular, the fact that the at a distance arrangement is described as an alternative to one in which the emitter and the sensor are within the socket, nor the application of that disclosure to figure 5. The judge only considers that in the context of figure 2, which he has, for reasons I've already indicated, wrongly held only allows for the possibility of separation. And also for those reasons, I say that both embodiments in non-Schwander are disclosed and unambiguously disclosed as having the power control circuitry located separately from the socket. And the judge's reasoning for finding otherwise in 147 proceeded on an incorrect basis in overlooking the express disclosure of the document in respect to both of those features.
I haven't quite understood what it is you're saying at this point that the judge has overlooked.
Right. What he's overlooked.
I know you say you don't agree with it, I get that. But what exactly is it that the judge has overlooked?
The passage that bridges columns 3 and 4 of Neuschwander. So, the bottom of column 3, page 16 is Neuschwander.
That's the bit that he quotes, the at a distance.
No. The key passage between 3 and 4 starts at line 57, column 3. There's a paragraph that discloses an arrangement in which both the emitter and the receptor are arranged within the receptacle. Then, starting at line 66, there is an alternative arrangement in which the emitter and the receptor may be arranged at a distance from the respective opposite ends of the barrier portion. And in that case, they are connected to opposite ends of the barrier using optical conductors.
But he was obviously aware of that because he's used the language of within the receptacle in 1464, hasn't he? I mean, it's all rather compressed, but you can see what he's saying there. He's just simply highlighting the second of the two possibilities.
I'm sorry, I just don't find where you're
No,
going to. From the respective opposite ends of the barrier portion.
He says 66 to 68. He says we refer to the possibility of emitter and receptor not being within the receptacle, but being at a distance. So I took the not being within the receptacle as being a reference to the first of the two ways of doing it, which is described, it's true, not in 66, but in 56 or 57 onwards, because that's the language, isn't it?
Yes, but my lord, I accept that. I accept that he has referred there to not being within the receptacle.
Yeah.
But my submission is that although that may be there, if he may have referred to it, but he doesn't, put it this way, he doesn't appear to have understood it.
All right.
And when when I say I criticise him for not understanding it, I appreciate that that's a severe criticism. The disclosure in that paragraph is, in my respectful submission, absolutely clear. That when one is talking about not only the receptor and the emitter being at a distance, but also being connected to the opposite ends of the barriers by optical conductors.
I mean, I was only reacting to you saying that the judge had failed to take into account or ignored it or something. I don't think that's quite fair. I think he clearly had it in mind because of the way he expressed himself.
Well, perhaps, and I understand that observation. I do take that on board. But there are essentially then two parts of the judge's analysis. The first is to say, well, I look at figure 2, and I'm paraphrasing the judge here. I look at figure 2, it looks like it's schematic to me. It's possible that it discloses separation. It's possible that it doesn't. Now, I do criticise the judge firmly and squarely in that respect, because he has overlooked the textual disclosure of the separation between the conductor ends, which is in column 6. Now, having made that error, one, I suppose, might understand that when it comes to the disclosure of at a distance, the judge says to himself, well, what does it really add? But if he'd appreciated properly figure 2, then when you look at what's being disclosed in the bridging column between 3 and 4, I think those two together make it unambiguous that when one looks at figure 5, where the optical conductors are going out through the base plate, they're going out the base plate. Where are they going? They're going to relays and so on, which are outside of the receptacle.
The thing I'm not understanding about your submission, I understand the submission that you're making, that the passage from line 66 at the column 3 over to line, whatever it is, on column 4, the end of that paragraph, that text, coupled with the images, figure 2, and, as it were, a bit of thinking about it, what it all means, you say that discloses separate between the power supply unit and the socket. I understand that case. Right or wrong, I understand what you're saying. The bit that I still don't follow is what's the significance of the... You placed repeated emphasis on the fact that there's an alternative. You've referred to the section from 56, line 56 of column 3, and there clearly is. There's clearly a disclosure of... There's a paragraph which begins at line 56 or 57, and then an alternative paragraph that is 66. And I understand the argument that the alternative paragraph discloses separate.
Yes.
What I don't understand is what the first paragraph, what part that's playing in your argument. You've said it so many times that you obviously think it is playing a part in your argument, and I don't understand what it is, so if you'll forgive me.
Well, your Lordship is right, it does play a part in my argument.
Okay.
And obviously I haven't been anywhere nearly sufficiently clear as to why. Okay. Let me try to recap. The particular significance that I attach to the paragraph between lines 57 and 65, which is the one that precedes the key one, is that contains what I submit is a clear disclosure of the emitter and the receptor being within the receptacle.
Okay, that makes sense, I get that.
And therefore, when the next paragraph suggests alternatively the emitter and the receptor may be arranged at a distance, and explains that in those circumstances the emitter and the receptor are connected to opposite ends of the barrier by way of optical conductors, and you then look at figure 5, for example, and you see optical conductors passing through the base plate, that, as an alternative to being told that the emitters and receptors are within the housing of the socket, in my submission amounts to a clear and unmistakable disclosure that, at least in figure 5, the power circuitry, which is responsible for switching the power on and off to the socket, is outside of the socket.
I see. So it's the contrast between the two, you say,
It
emphasises the quality of the second one that you're relying on.
Exactly.
Thank you. I've got it. Good.
Could I make, finally on this topic, deal with a point which is made by my learned
So you're challenging
Yes.
the judge's comments in 147, considerable room for argument, and it doesn't contain any clear and unmistakable direction. You say there isn't considerable room for argument, and it does.
No, I actually say
So-
that it does unambiguously
Yes,
disclose
exactly.
separation.
Exactly, yeah. That's,
I mean, that's the end point. The end point is fundamentally what I attack, is his conclusion in the first line of paragraph 148. It did not contain any clear and unmistakable direction in that respect.
yes, and also
does.
considerable room for argument, because you say there isn't. Oh, and it's the same point. Yeah.
Well, of course, you're also right. If there was still considerable room for argument, then I'd have difficulty challenging the final conclusion.
Yeah.
And the legal significance of this is the words clear and unmistakable directions are actually a buzz phrase, a buzzword in the patent concerning the legal test for novelty.
Correct.
And clear and unmistakable directions is the antithesis of an anticipation of something which deprives something of novelty. That's what you're attacking, because you say
Yes.
it does deprive the claim of novelty because it's not, because it's clear
And unmistakable.
it's clear and it's unmistakable, not
Yeah.
not clear and unmistakable.
Absolutely right. Very good. So just one last point on this topic is just to address a point which my learned friends make, and they make it with some vigour. And they say, well, hold on. The judge is absolutely right to conclude as he did, not least because of one of the stated aims that Newshander seeks to achieve is, they say, to provide that all of the apparatus that is involved in his invention should ideally be placed inside the socket. Can I just show you which passage they rely upon, and then I'll tell you what my submission is and as to why that is incorrect. If you take page 15 of Newshander, on the right-hand side, under summary of the invention, starting at line 35, there are references to a number of primary or important or further important or yet further features of the present invention. At line 50, Neunschwander discloses yet a further feature of the present invention is directed at a safety receptacle, wherein the features needed for safe and simple operation do not require more space than is available within a receptacle of conventional construction. And my learned friends characterise that as a disclosure or a teaching by Neunschwander that everything, the light barrier, the associated circuitry for switching the power when the plug is inserted, should be housed in the socket. Now, not only is that not what Neunschwander says, but if one reads on in Neunschwander, it is perfectly apparent that what his particular concern is, in that respect, is that the barrier should be housed within a single, ideally within a conventional socket. So if you turn to page 19, column 9, left-hand side at line 59, Neunschwander says, generally, in a safety receptacle according to the invention, all elements required for the light barrier means can be arranged within the receptacle without increase of the receptacle volume. And of course, that's what one sees in the specific embodiments, which is the light barrier means whether it's a longitudinal light barrier or it's two separate light gates are housed within the receptacle, but in both cases the conductors are exiting the receptacle and so on.
Does the document somewhere tell you what's within the scope of what the light barrier means is?
The discussion of what the light barrier means is.
I mean, the point is obvious that it might be the bar, or maybe it means everything. Your point you're putting to us, I mean, I don't know what the answer is to this question. Sort of, you know,
Yes,
see what I mean?
It's in column, I think column 3.
Oh, I see. Line 45, barrier portion.
It starts a little earlier, actually. It starts at, I think it starts at line 19, preferably a theoretical line of pin movement is defined beneath. Further, according to this preferred embodiment, the light barrier, when in the at-rest position. Well, can I chase that down? 39. I'm told 39.
Generally include.
Yes. Light barrier systems are known per se, line 39, generally include a light source or emitter, a light sensor or receptor. So that's a light barrier system.
Come back to it.
Look, can I come back to that? And also that concludes my submissions in relation to anticipation of claim 1 by Neunschwander. And it is on that basis that I seek the court's permission to raise that and seek a determination on that issue too. Can I now turn to obviousness of claim 1, again over Neunschwander. Of course, if Neunschwander anticipates claim 1, then the fact that claim 1 is obvious over it doesn't matter. The trouble is, it depends what ultimately your lordships conclude is the correct construction of remotely. In particular, was the judge right to say it means something that's far away, or am I right that it means something that is simply separate? So I think for these purposes I have to make my submissions on the assumption that your lordships are against me as far as remotely is concerned, and the judge was right to decide that remotely would include, for example, what is shown in figure 1 of the patent, with the supply device located underneath the seat.
On this topic, though, for inserted, you have to win.
I'm sorry, I should have made that absolutely clear. I have to win on inserted. Well, just to be clear, if I don't win on inserted, then I have to win on insufficiency.
Yes, okay.
So if I don't win on insufficiency, then I have to win on inserted. Yeah, absolutely. So can I take the judgment with respect to obviousness, and starting at paragraph 193. The judge directs himself correctly as to the principles, and he makes it clear that he is going to be applying the structured windsurfing portfolio approach. He's already made findings as to the skilled person. He's made findings as to the common general knowledge, and we'll look at some of those in due course. And in paragraph 246, he identifies the concept in claim 1 that he's going to have to consider for the purposes of obviousness over salati. So it's the last sentence of 246 in particular. In particular, there is a switch in the supply device which turns the power on and off by reference to a condition detected in the socket, and the supply device is located so as to be remote from the socket. Now, salati is no longer relevant. It's been dropped for the purposes of this appeal. And the judge, when he comes to consider Neunschwander, deals with salati first and then applies his reasoning to Neunschwander. Now, I fully accept, my lord, that obviousness is, as the judge rightly said, a jury question. But my submissions are this, that in finding claim 1 non-obvious over Neunschwander, I will be submitting to your lordships that the judge fell into error in 2 respects. 1, taking account irrelevant matters, and secondly, failing to take into account relevant matters. And what I propose to do, if I may, is show you the judge's reasoning in relation to salati, and having shown you his reasoning in relation to salati, make my submissions as where I say the judge fell into error so far as he applied that reasoning to Neunschwander. There is one bit of salati I think that I need to show you, just so we understand, or so it's clear what the judge is considering when he makes his findings of non-obviousness over salati. So can I just show you that very briefly? Salati is in the supplementary bundle, the first supplementary bundle, tab 3. And on page 22 is the first of 2 figures. And so on page 22, figure 1, there's a plug on the left, there's a socket on the right. The switches are labelled 9. They're at the bottom of the plug holes, and the circuitry for switching the power on and off is all located within the socket. So plug on the left, socket on the right, all the power switching is within the socket. And the argument about salati at trial was what is disclosed in figure 2. And in figure 2 you can see a double socket. I say you can see a double socket. I hope your lordships can recognise a dual socket on the left-hand side. And figure 2 includes the power control circuitry for the upper of those 2 sockets. With 2 switches, again labelled 9, and they're connected in series to what is called a triac. And that triac switches high voltage on and off to the socket. And what the judge decided, and I don't challenge any of this on this appeal, is that figure 2 does not contain a clear and unmistakable direction to separate the power supply from the socket. And in particular, in paragraph 182 of the judgment, he questioned whether figure 2 was to be read as showing the location of the components at all, rather than simply how they're wired up, for 3 reasons. One is that the triac is not enclosed. Triac is not enclosed, then it's going to be the subject matter of no end of electrical discharges to anyone or anything. Second, the wire between the switches, so between switches 9, is shown outside the socket. And third, the dotted line which represents the connection to the indicator light on the front of the socket, is also shown outside of the socket. So in this case, the judge found that actually it was indeed questionable whether this was actually showing location of components at all, rather than simply wiring. Now, you can put Salati away and go to judgment. And what the judge does is to undertake a two-step analysis in relation to Salati. Paragraph 249. He says, I will begin by discussing what might have been technically obvious if the uninventive skilled person had the idea of installing a high voltage AC ISPSS. And in the next paragraph, 250, he begins quite rightly with what Salati itself discloses. And he explains that Salati didn't disclose remoteness. It did not provide for remote separation of the switch, which turned on the power from the socket. Furthermore, I don't think that figure 2 in Salati would suggest that thought to the skilled person, given that figure 2 was included to describe something different. So that's his characterization of what Salati itself discloses. And then in the next 3 paragraphs, he makes some further findings. Again, this is all, to be clear, just in the context of Salati. Paragraph 251, he says, further as to Salati, it dealt with the knitting needle problem in a way which was different from the well-known use of shutters in a conventional socket or a shaver point, but did not deal with the double knitting needle problem and did not really deal with the drenching problem. I'm going to park, if I may, those submissions and come back to them when I'm dealing with Neunschwander. Can we just park those for a moment? Then in paragraphs 252 and 253, he addresses the ARINC specification and the M-Power system. We've talked about the ARINC specification previously. The M-Power system was one of the existing ISPSS systems that were available at the priority date, which is acknowledged in the patent. And what he finds is that although they show separation in the case of ARINC between bulky components and controls, and in the case of M-Power between the ISPSS and the socket, neither discloses or was known to use a remote switch which was turned on and off by reference to a condition detected at the control or socket. Now those findings, which I don't challenge, are plainly significant when one is starting with Salati, because as the judge has held, Salati does not provide for remote separation of the power switch from the socket, nor even suggest that thought to the skilled person. And then in paragraph 254, there's the conclusion, claim 1 is not technically obvious in the light of Salati. Then in paragraph 257 to 259, the judge refers to his findings, or makes findings in relation to the skilled person's mindset. And in 258, although he has already found that claim 1 was not technically obvious in the light of Salati, he refers to the mindset or prejudice involved in the common general knowledge as an additional reason why the design in claim 1 would not have been obvious to the uninventive person. Let me just show you what how the judge then approached Neunschwander. So over the page, paragraph 261, having construed claim 1 of Neunschwander, I'll now proceed on the basis that the concept in claim 1, which is said to go against the requirement that the plug is fully inserted in the socket, and the voltage supply is remote from the socket. As to the feature of remoteness, parties made essentially the same submissions as they made in relation to a similar point in respect of Salati. I reached the same conclusion. The design in claim 1 of the patent was not obvious over Neuschwander. And then he makes the point that I think my Lord Justice Birss has just indicated that the lack of full insertion, I need to win on that, on the construction of full insertion. Now, my appeal in respect of the judge's findings, or finding of non-obviousness of claim 1 over Neuschwander, is very simple. Can I address you first on the question of technical obviousness? The inventive concept of claim 1 as found by the judge in 246 is that there's a switch in the supply device which turns the power on and off in the socket by reference to a condition detected in the socket, and the supply device is located so as to be remote from the socket. On the judge's findings, Salati does not provide for remote separation of the power switch from the socket, nor even suggest that thought to the skilled person. Neuschwander, however, is a fundamentally different starting point. On my case, Neuschwander discloses clearly and unambiguously a device in which the socket and the supply device are separate. And the judge has found, when dealing with the ARIM specification, that it would be desirable, indeed obviously desirable, to place an electronics box out of the way, under the seat, for reasons of cabin design and convenience. As it happens, there's no question that that would address the risks caused by liquid ingress into the socket as well. So, my lords, on my case, as to what Neuschwander clearly and unambiguously discloses, that is the beginning, the middle, and the end of the technical obviousness case, subject to one point. And the one point is the one that I ask your lordships to park, which is the finding that the judge makes in paragraph 251, where he refers, at least in the context of Salati, that Salati didn't deal or doesn't deal with the double knitting needle problem. Now, it's possible, indeed I think it's a reasonable inference, that the judge has relied upon that as a deficiency in Salati to support his overall conclusions as to non-obviousness. And therefore, when he thinks about Neuschwander, I think it's right to assume that the judge has also considered that the fact that Neuschwander does not solve the double knitting needle problem to be a relevant consideration. Now, insofar as that formed any part of the judge's reasoning in relation to Neuschwander, my submission is that was a plain error. And the reason that it was an error is not because Neuschwander's specific embodiments do in fact solve the double knitting needle problem, but because the invention which the judge is considering here, which is claim 1, the invention of claim 1 does not solve the double knitting needle problem, as the judge found in paragraph 260. And the principle here, my lords, is that a deficiency or a shortcoming in an item of prior art has no relevance to obviousness unless it it is a deficiency which is solved by the patentee's invention. And if authority were needed for that, my lords, we do have Phillips and Ausustek, where I think it's most clearly and concisely stated. Could I hand a copy of that up to each of you lordships?
And your inference is based simply on the way the judge puts it in paragraph 262, that he reaches the same conclusion that you insert for the same reasons.
Indeed, and I mean, it may be that actually, well, I think I think it's quite clear when he's dealing with Salati that he appears to think that that's a relevant consideration.
Yes.
Whether it's a relevant consideration for Salati is neither here nor there, because Salati is part of the appeal. But insofar as it's thought to be a relevant consideration for purposes of Neunschwander, then the judge was wrong to take that into account, because he's looking at a double knitting needle problem as being something that Salati doesn't solve.
Yep.
That isn't relevant because the invention doesn't solve the double knitting needle problem. Lord Justice
Just trying to
is
understand.
frowning.
Yeah, I am, because I understand the point you've made. That the finding was that Claim 1 doesn't deal with the double knitting legal problem. And of course you're right, the judge pointed out at 251 that Salati also doesn't, well he didn't say also, but he says doesn't deal with the double knitting legal problem. I would understand the submission that you're making if it was apparent that the relevance of the double knitting needle problem had something to do with the alleged obvious step that you were putting forward to the court as being the step to take over Salati to reach the claim in suit. But
Right.
you're not.
Not
So
for,
I
not,
don't
for,
understand.
not for the purposes of this claim, no.
Right. So I don't understand why it matters.
Right, well,
If you weren't saying that it was obvious, if the reasons you were saying why it was obvious to go remote had
yes,
something to do with the double knitting needle problem,
yes.
then I could understand why this had something to do with it all.
Right.
But you weren't, so I don't.
In that case, your lordship is cut right the way through it. It may not matter at all in those circumstances,
Okay.
because the reason that I get on my case to the invention is by taking the disclosure of Neunschwander separate and combining that with the judge's finding in relation to Aring, which is plainly, for matters of cabin design and convenience, desirable to put electronic boxes underneath seats.
Right.
And so I think your lordship is right. The way in which I am now putting my case, and as far as Claim 1 is concerned, I was not relying upon solution of the double knitting needle problem as a way to get to Claim 1. It comes into Claim 2, but not into Claim 1. Then we can cut through all of that.
Okay.
I think that's right. Yeah. Yeah. Right. That short circuit things. Now, so far, on obviousness of Claim 1, starting with the disclosure of Neunschwander, I've dealt with technical obviousness, and I've addressed your lordships on why putting the power supply circuitry of Neunschwander in a box under a seat is obvious. I now need to address your lordships on mindset, because the judge has made findings as to the skilled person's mindset, and your lordships need to know precisely where I say that the judge was right and where he was wrong.
You just handed this up.
Yeah.
Were you taking us to this now? Was this
I
or not?
I'm going to come. Can you hang on? Can you hang on to it? And
Right.
I'll come back to a paragraph. I think where it will still. Lordship will remember this.
Yes, it's a dreadful case.
Right. I'm sorry to hear that. Excellent judgment. That was Mr. Barrett. My lord, so can I deal with mindset? And let's just show you where the judge made certain findings. In paragraph 217 of the judgment, having dealt with various safety problems, the judge turns to the mindset of the skilled person and he reviews a number of contemporaneous documents. He reviews certain documents that postdate the priority date. He reviews evidence that was given by Mr. Borowski, and in paragraph 236 he makes findings based on the contemporaneous documents, the oral evidence, as to the mindset of skilled persons of the kind identified by Mr. Borowski. 1, 2, 3 and 4. And in 237 he makes it absolutely clear that he is considering the mindset of the skilled persons of the relevant kind taken as a whole, not just the mindset of some of them. Now, I don't challenge any of those findings made by the judge. What I do say, however, is that the judge has left out of his account of the mindset of the skilled person a particular matter that is of some significance. Indeed, it is one very important consideration. And can I show you, I'll tell you what the consideration was, and then I'll show you a document that goes to that. The particular consideration that the judge has left out of account is that there was no question on the evidence that an ISPSS system which allowed electronic devices to be plugged into the seat socket with a normal mains plug, just as one would do at home, would be regarded by passengers, quite understandably, as the most preferred solution. So in other words, if an ISPSS system could be developed that used mains voltage, there was an overwhelming and clear desire to develop such a system because of the obvious convenience that it would bring passengers. And can I show you two documents to that effect? First of those is in his first supplementary bundle, tab 8. Sorry, tab 10. Apologies. Now, it's not a very good photocopy. This is a paper that was exhibited by both experts. It appeared in a publication called Avion, which was the official publication of the World Airline Entertainment Association, and this is from an edition of Avion relating to that association's annual conference in Seattle in September 1996. If you turn please to page 189.
1996. What did you say, 86?
I should, 1996. So if you turn to page 189 of the bundle, and on the right hand side, under the heading "and then came mpower," you'll see airlines have known the need, passengers have made known their wishes. When business travellers fly, they want their seats to be extensions of their offices, hence faxes are now sent, telephone calls are now made, and work is now done all from aeroplane seats. While an increasing number of commercial aircraft, phone and fax capabilities are provided by airlines, but personal computers have always been the special domain of passengers. They carry them aboard, they provide the power to run them, so it's common sight to see laptops in use during flights, at least until the batteries run down. Why can't I plug my computer into aircraft power? Has been a prevalent question of passengers. Born out of frustration, there's nothing worse than being in the middle of an important project when your computer batteries give out. So that's the background that then leads into the account of the mpower system, which was a DC system. And in our skeleton argument for the purposes of this appeal, we referred in paragraph 112, or in paragraph 112 of our skeleton, we made this point. So the judge set out the relevant mindset of the skilled person in 236. His analysis focused only on perceived disadvantages of an AC power supply system. He left out of account altogether Professor Wheeler's evidence as to the advantages of such a system, including in particular that it would allow the passenger to plug his or her device, usual power battery into the socket directly with its normal mains plug and without the need for some additional connector. Such passenger convenience is a substantial benefit established uncontroversially by the evidence, and it fell to be considered by the judge's analysis, but was not. There's no evidence reference that's given there. Can I give you the evidence reference to support that proposition? It's bundled, well, it's day 2, page 108, line 18, to page 111, line 14. Now, the submission to your lordships is in the judge's account of the relevant mindset. That clear advantage of an AC-based system features nowhere in the judge's account of the skilled person's mindset. And when one then turns from 236 to paragraph 257, nor is there any reference to that that advantage in his account of the 3 findings in paragraph 257. But what there is in paragraph 257 in Little Roman 3 is a finding by the judge that the skilled person would know that if his design was not a significant improvement on existing systems, it would not be certified by the CAA. My lord, the patent in suit contains no suggestion that the invention of Claim 1 will be certified by the regulatory bodies, or any teaching as to how certification can nevertheless be obtained. So insofar as the judge is finding in paragraph 257 that there was a problem to be overcome in terms of developing a solution that had sufficient improvement on existing systems to be certified by the CAA, that is not a problem which is solved by Claim 1 of the invention. So to summarise, my lords, as far as obviousness of claim 1 is concerned, my submissions to your lordship is that claim 1, starting with Neunschwander as a disclosure of separateness, combined with the judge's finding in relation to the desirability of placing electrical components in boxes under seats in paragraph 208, makes subject matter of claim 1 technically obvious. The advantages of an AC system in terms of passenger convenience were readily apparent, and concerns as to certification should not have formed any part of the judge's evaluation in relation to claim 1. Yes. Only 2 paragraphs. First is paragraph 59, which is actually a recitation of the underlying principle behind prejudices as they apply to obviousness that comes from Pozzo. So paragraph 59 to be read in its entirety. And then paragraph 63, paragraph 73, where Lord Justice Floyd, who I think was giving the, Lord Justice Floyd, explains that, refers to Pozzovi, and he says the principle is you cannot have a patent for doing something which a skilled person would regard as old or obvious, but difficult or impossible to do, if it remains equally difficult or impossible to do when you've read the patent. But in another way, the perceived problem must be solved by the patent. So it's those two, that paragraph combined with what was said in Pozzo. Right. Can I move on to claim 2?
Just before you do, Mr. Adler, I'm sorry, last question on this topic. You've explained your case that you say the judge missed. You don't challenge the findings on mindset in 236, little 1 to little 4. No. You say that what was the error, if you will, is to miss out an extra one.
Correct.
Which is about the desirability of AC for passengers. What I haven't understood is how it interacts with the ones that you don't dispute, because and I ask you that because I realised that I hadn't, when I listened to your submission, I'd forgotten about those 4 points when I was listening to it, thinking it was jolly attractive. And then I went back and read the 4th one, 236 little 4, is that the design of the system ought to be for a low voltage DC system, which seems to cut precisely against the point that you made, that you want to have an AC system. So at the very least, I'd like to understand how it all fits together. If you just focus on the one that you say the judge missed out and forget about the 4 that you don't dispute, then that's one thing. But that's not your case. As I understand it, your case is you should have those 4, but also an extra 5th one. But the extra 5th one you want seems to run rather contrary to at least one of those 4. I'm just trying to understand how you put your case that way.
Right. Okay. The way I put my case is that the moment the judge's language, the design of an ISPSS ought to be a low voltage DC system, taken as a finding completely independent of the advantages of passenger convenience and so on, is one thing. Right. But if I think the submission is when you read the judge's finding ought together with that additional benefit that comes from that derives from an AC system, it downplays the significance of ought to be a low voltage DC system. I don't say it neuters it, but I do say that it impugns the weight that is to be attached to little 4 of paragraph 236. Claim 2. So the judge's analysis of Claim 2 followed the same approach as he had in relation to Claim 1. That is to say, Claim 1 was not obvious over Salati, nor obvious over Neunschwander for essentially the same reasons. And I'm going to adopt a similar approach, my lord, in showing you first how the judge dealt with Salati in relation to Claim 2, and then explain to your lordships where the judge fell into error when he applied that reasoning to Neunschwander. So if I could ask you to start with paragraph 266 and 267 of the judgment. And in 266, he refers to a number of submissions made by Mr. Cuddigan on behalf of Lufthansa. 267, he refers to submissions which I made. And my lord, there is no dispute as to the submissions which are recorded in 267, 2, 3, 4, and 5. So just taking them in turn, Claim 1 of the patent didn't solve the double knitting needle problem that Claim 2 of the patent did. Correct. Number 3, the skilled person would want to improve safety over earlier designs and would want to solve the double knitting needle problem. Correct, for the reasons which the judge has given in paragraphs 210 and 211. The skilled person, this is number 4, would want to improve on the shutters used in a conventional plug or a shaving point. Correct, for the reasons which are given in our skeleton at paragraph 121. 5, the skilled person could, without difficulty, design circuitry to introduce a timing feature. Correct, for the reasons given in our skeleton at paragraph 122. In 268 and 269, the judge refers to a pleading point taken by Moylan Express. In 269, he finds that the evidence at trial was that the timing device contributed to safety, and he's going to rely on that evidence, and he doesn't need to consider the pleading point. And then 270, he finds that the invention of Claim 2 is not obvious over Salati. He says, I'm not persuaded that the technical evidence shows that a designer of an ISPSS would introduce this entirely novel feature when it did not appear in Salati, which was a design intended to enhance safety. Now, I don't challenge that conclusion. The question is whether the judge's reasoning there applies with equal force to Neunschwander, or whether there is material in Neunschwander which the judge has left out of account for the purposes of Claim 2. Can I show you what Neunschwander does disclose that is relevant to the timing feature, and then the judge's findings in this respect. Could I ask your Lordships to take page 16 of Moylan. And there are two bits of text to show you. The first of those is in column 3, at line 18 to 28, where non-Schwander is discussing a preferable arrangement. Preferably, a theoretical line of pin movement is defined between each front plate opening and the connector and associated therewith. Furthermore, according to this preferred embodiment, the light barrier will maintain said relay in a contact breaking position when at the arrest position in the absence of plug pins, and will operate the relay for connection of the connect end with the supply line only when the contact pins are moved simultaneously along the theoretical line of pin movement. That is the first disclosure. And the second is when we come to the claims, which are on page 19 of Moylan. We haven't looked at the claims before. Let me just show you the key features of claim 1 first of all. So I'm looking at page 19, column 10. Claim 1 introduces a number of features. At line 16 there are 2 connector ends. Line 27 there's a relay. Line 30 a light barrier means connected with the relay. And if we then turn to claim 2, it's clear that the subject matter of claim 2, insofar as it refers, as it does at lines 43 to 44, to light barrier means which maintain light barrier means is arranged to maintain said relay in a contact breaking state when in the at-rest position, in the absence of an attachment plug. But that, in my submission, is clearly a reference to the first embodiment because of the references to the barrier means being in a relay contact breaking state when at the rest position. And one gets that from column 6 at lines 17 all the way through to line 49. Now, claim 2 goes on to say at line 49 to 50, the light barrier means causes the relay to make electrical contact only when all pins are moved substantially simultaneously along the lines of pin movement. And just make a note, if you will, my lords, of that. Only when contact pins and attachment plug are moved substantially simultaneously towards and into contact with the said connector ends. That same language is repeated in relation to claim 3. Now, claim 3 refers to a receptacle wherein the light barrier means includes 2 barrier portions, each of which is associated with one of the connector ends so as to operate the said relay for connection of the said supply line. Now, the reference to 2 barrier portions is quite clearly a reference to the second embodiment. And one can see that at column 5, line 24, and column 9 at lines 50 to 55. But again, the language at the end of claim 3, the relay is operated only when contact pins of an attachment plug are moved substantially simultaneously towards and into contact with the said connector ends. Now, if one looks at the second embodiment in figure 5. Plainly, if, as is shown in figure 5, a genuine plug is inserted into the socket, the pins will move toward and make contact with the connector ends substantially simultaneously. But it's equally clear that the insertion of a genuine plug is not the only circumstance in which the supply voltage in the second embodiment will be triggered, as the judge found in paragraph 142. Paragraph 142, he's talking about the second embodiment. He says the second variant, on the other hand, has no bulky or hindering mechanical element, and therefore better satisfied both the second and third aims, but it did not have the additional benefit of requiring the right side diameter pins, as the second variant could be turned on by the insertion of 2 separate probes. That's the judge's finding, and as Professor Wheeler explained, figure 5 would be triggered by the sequential insertion of 2 knitting needles.
What is it about figure 5 that makes that different from figures 1A and B? Is it that you need the right size of pin to make the chamfered angle on the light barrier?
Yes, it is. As far as the first embodiment is concerned, you have to get the right size or chamfer of the pin to get the right degree of lift of the barrier, the bridge.
Yeah.
But that doesn't apply in the case of the second embodiment.
Because you can break the magic eye circuit within it as long as it doesn't matter how big it is.
Well, I suppose it's got to get through the
It's
aperture.
got to be big enough, but yeah. Yes,
It's got to be big enough and not too big to get through the aperture of the socket. But other than that, there's no limitations to it. Now, if we then take the judgment at paragraph 151, this is, we can pick it up actually at paragraph 159, where the judge says, I need to consider whether Neunschlander disclosed the timing feature in claim 2 of the patent. It says claim 2 of the patent referred to a feature which produced the result that the supply voltage was only supplied to the socket if the maximum contact time was not exceeded. If you read on to paragraph 151, the judge refers and accurately recites the disclosure at column 3, lines 19 to 20, which is the one that we just looked at. And in paragraph...
159, I think you went 149.
Oh, did I? I'm sorry. I may have misspoken. In other words, I'm looking, I started with paragraph 149 of the judgment, and I then referred to paragraph 151 of the judgment, where the judge refers to the passage in column 3, and I then was referring to paragraph 152 of the judgment, where the judge correctly characterises and recites the language of claims 2 and claim 3. And then the next port of call, and this is the critical port of call for the purposes of my submissions to your lordships, is what the judge says in paragraph 160. And in paragraph 160, the judge, in my submission, entertains 2 possible interpretations of the disclosure in column 3 and the disclosure as stated in claims 2 and 3. One is that they signify, he says, I can see how it might be said that the statement in column 3 and disclosures in claims 2 to 3 signifies some feature which would not allow the supply of voltage unless the pins move substantially or simultaneously or substantially simultaneously towards the connector elements. But he goes on to say it is entirely possible that what Neuschwander was attempting to describe in the relevant text was what would happen in the ordinary case with the ordinary plug. And the key point is what his lordship says at the end of that paragraph, rather than attempting to refer to a feature of which there was no other hint, and which would require further thought and design. Now, my submissions to your lordships is what the judge is there doing, is there acknowledging, indeed finding, that Neuschwander does hint at a feature which requires simultaneous or substantially simultaneous insertion. Because he refers to, he entertains the first possibility. And he refers to the second, namely the insertion of a conventional plug, as being something that is entirely possible that is what Neuschwander was attempting to describe, rather than attempting to refer to a feature of which there was no other hint. So my submission to your lordships is that the judge has recognised correctly that Neuschwander hints at the feature which he's describing in the first 4 lines of that paragraph 160. Now, in those circumstances, when we turn back to the judge's reasons for finding salati, or rather finding claim 2 non-obvious over salati, and in particular in paragraph 270, where the key piece of reasoning in relation to salati is that he is not persuaded that the technical evidence shows that a design of ISPSS would introduce this entirely novel feature when it did not appear in salati, which was a design intended to enhance safety. That is fair dues as far as salati is concerned. My submissions to your lordships is the judge has made a finding that there is a hint of such a feature in Neuschwander. That hint, combined with the considerations that are accounted for in little 2, 3, 4 and 5 of 267, as to which you heard my submissions that there was no dispute, make the implementation of a timing feature an obvious implementation of what is hinted at in Moylan. So it's a short point as far as claim 2 is concerned, my lords. Can I then, subject to any questions your lordships have on claim 2, can I then turn to claim 3, which is the last topic. And in order to explain how Claim 3 now comes in on my application at this stage in this appeal, I think the most convenient way to start, at least, is to show your lordships how the case was put below in front of the trial judge. And once that is appreciated, it may be a more straightforward manner to explain the rights and wrongs of where we now stand. Are your lordships content for me to approach it that way?
Thank you.
So could we start with Mr. Borowski's evidence, which is, he was my expert, and it's in the supplementary bundle tab 1, sorry, supplementary bundle 1 tab 8. And if I can ask your lordships to turn to paragraph 165. Sorry, it's not, it's paragraph 182 is where it starts, page 164. So internal page 31, paragraph 182, and Mr. Borowski is talking about lack of inventive step over Neunschwander in respect of claim 3 at this stage. He refers to claim 3 as specifying that the plug detector comprises mechanical switches. He says switches were used in the OAC and power system. There's nothing for current purposes that I wish to rely upon in relation to 182. It's in 183 and 184 that the relevant evidence is there. And perhaps if your lordships can just read to yourselves 183 and 184. So the witness is there in my summary characterising the advantages and disadvantages of electric compared with mechanical solutions. And of course this is evidence in which the witness is not advancing a case that there is something in Neunschwander which points towards mechanical switches. He's getting to claim 3 of Neunschwander, mechanical switches, by application of essentially common general knowledge. Now I should then show you the evidence that Mr. Borowski gave when he was cross-examined on that. That is in supplemental bundle 3, tab 23. I'm going to use the pages, the transcript pages, if I may. It's page 610. Starting at line 18, and running through to 612, line 3.
So, sorry, line
page 610, line 18.
Bottom right hand. Sorry, when you say 610, you're doing 610 with the bundle page.
No, I'm not. I'm sorry. It's page 600 of the bundle. I apologize. So page 600 of the bundle. It's the internal page 610 of the transcript.
Yeah.
Starting at line 18, going over to transcript page 612, line 2.
And you want us to read that, or?
Please. It's only a page and a bit.
Yes.
So that was Mr. Borowski's evidence, and I shall show you Professor Wheeler's evidence on the same topic, and that is in Supplementary Bundle 1, tab 6, page 101. And when I say 101, that's the bundle reference, it's internal page 56.
Sorry, wait a minute. Supplementary bundle 1.
Yes.
Tab
6.
Yes.
Paragraph 248, which is bundle reference 101, internal page 56.
Yes.
And if your lordships could just read 248 yourselves.
Yes.
That was the evidence, and that is the totality of the evidence that arises on this issue. This isn't an issue in which I would be suggesting for a moment that there should be further evidence that is called. It's a short point. It arises in relation to an issue which the judge did not need to make any express findings, because he had already found that both claims 1 and claim 2, on which claim 3 ultimately depend, were both valid. It is fair to say that the judge did make a finding of infringement of claim 3, and he also certified that the validity of claim 3 had been unsuccessfully contested. But my lords, as I say, it is a short point. The evidence is there. There is nothing more to be said in relation to the assessment of claim 3, other than this, which is my learned friends characterise my application to amend the grounds of appeal as necessarily involving the withdrawal of an admission, and I don't accept that. What I do accept is that there is nothing in Neuschwander on which I relied for the purposes of attacking claim 3, as one sees in the evidence that was given by Mr. Borowski. I rely upon Neunschwander to get to claims 1 and claim 2. In order to get to claim 3, I'm relying upon essentially the claim general knowledge.
Sorry, just to make sure I understand what you mean. When you say you're relying on the common general knowledge, you don't mean that your case is that claim 3 is invalid over common general knowledge alone.
No.
You're saying it's invalid over Neunschwander.
Not, it's invalid. Claim 3 is dependent upon claim 1.
Right.
I can't attack claim 1 without starting from Neunschwander.
Right.
Assume I get to claim 1 from Neunschwander. In order to get from claim 1 to claim 2, I'm not relying upon anything in Neunschwander.
You mean 3?
I'm sorry, I mean 3. I'm not relying upon anything in Neunschwander. I'm simply relying upon the common general knowledge as to the use of mechanical compared with optical switches. That's all I have to say about claim 3. It's a short point. I invite your lordships to consider.
That's it. And no question. Any question? Sure.
Yeah, that is the substance of it as well as the application.
Yes. No, I understand that. Yes. Thank you. Thank you very much.
My lords, if there's anything else I can assist you with.
No. Thank you.
Lords, I wonder if it would be convenient for me to start with that last amendment, given that it is an amendment. I'm happy to start with the construction issues that my learned friend opened with this morning, if you would prefer.
No, however you wish. But why not?
Given that it's fresh
Yes.
in our minds,
Yes.
you've just looked at some of the relevant evidence. Let's kick off with that. So my learned friend has taken you to some of the context that you need to consider for the amendment application, but not quite all of it. The effect of this amendment application is that the appellants want to argue for the first time on this appeal that claim 3 is obvious over Neunschwander. And as you've seen, the context for that is that claim 3 specifies the use of mechanical microswitches, whereas Neunschwander was exclusively concerned with light switches. We resist the amendment on 3 grounds. First, as my learned friend has just mentioned, it involves the withdrawal of an admission without any corresponding application. Second, it's too late without any sufficient excuse. And third, it's hopeless on the merits. As to that last point, of course, if you allow it in, I redeploy my arguments and say you should reject it on the merits. Now, the procedural history is relevant to all these objections, because it involves an account of the evidence and, importantly, the submissions before the trial judge, to which you haven't been taken. But let's start before the evidence. Let's start with the pleadings. We asserted infringement of claims 1, 2, and 3, and we said that they were each independently valid. That, of course, is why in the order from which my learned friend appeals, there was a certificate of contested validity in relation to claim 3. It was formally in issue at the trial. We said it's an invention independently of claims 1 and 2. Now, in response, the appellants said that all 3 claims were both anticipated by and obvious over Solati and Neunschwander. But they subsequently resiled from that position in the expert evidence of Mr. Borowski, again, which you were just shown. In the expert report, they no longer said that Neunschwander disclosed microswitches. They commuted their argument to one of exclusively obviousness. And as you've seen, the argument relied in particular on the skilled person conducting a failure modes and effects analysis, FMEA analysis, on the Neuenschwander embodiment, and as a result of that, perhaps being told to introduce mechanical microswitches. And now, in the evidence of Professor Wheeler, he accepted that the microswitches of Claim 3 were disclosed by Salati. So we've then got a very divergent position as between the two pieces of prior art. We didn't maintain that Claim 3 was independently valid over Salati, but we did over Neuenschwander. There was no dispute at all in regard to Salati because we accepted disclosure. And Professor Wheeler, in his evidence that you've just seen, explained that in his view, the skilled person would not have discarded the optical switches that were the core of Neuenschwander and replaced them with something else. Those were its key feature. Then we had the opening skeletons, which ran along the same lines as the experts' reports. The appellant's case was expressly dependent on Mr. Borowski's FMEA analysis. He said that deciding between a light barrier and mechanical switches would involve consideration of the pros and cons of each, and the skilled person would conduct an FMEA. And as you've seen, we challenged Mr. Borowski's evidence on Claim 3, and we got to the position, we say, something akin to a concession, that in the absence of necessity, the skilled person may not think to make the change with Neuenschwander to hand from optical to mechanical switches. Conversely, my lords, there was no challenge to Professor Wheeler's evidence on this point, that the skilled person would not have discarded the optical switches of Neuenschwander. Moreover, the appellants never put to him their positive case about failure modes and effect analysis. They simply didn't traverse the issue with him at all. Now, in our written closing, we relied on the absence of any challenge to that evidence, and we also referred to our cross-examination of Mr. Borowski. The appellant's position reflected what we say was implicit in their cross-examination of Professor Wheeler, which is that they were no longer maintaining their case in relation to Claim 3 and Neuenschwander. Perhaps you could take Supplemental Bundle 2, and I can show you their written closing. So this is tab 18. And if you could turn forward, please, to page 350 of the bundle. And the section on Neuenschwander begins towards the bottom of that page. But they addressed Claim 3 on page 356, paragraph 301. Astronics does not advance a separate invalidity attack against Claim 3.
So, page 356, paragraph
301.
301, thank you.
So, we started in the pleadings where battle lines were drawn. They moved back from that. They advanced some evidence on their fallback position about obviousness. They didn't put it to my expert. I challenged their position. And then in their closing, they say, we've not got a separate attack on Claim 3 over Neuenschwander. And contrast that, if you will, to the corresponding paragraph in relation to Salati, which is on page 267. we did not assert, they acknowledge there, they don't have a separate attack.
Sorry, wait a minute. Page,
Sorry, paragraph 267.
yeah, hold on.
There's no separate attack on claim 3 and 7 because Lufthansa does not assert either as independently valid over Salati. Pausing there, we say that as a matter of English procedure, that was an admission that claim 3 was valid over Neuenschwander. Oh, I should add that nothing further was said in oral submissions. And that was exactly the position that the judge recorded in his paragraph 245. The features in the claims which are said by the defendants to have been obvious are the features described in claims 1 and 2. That was the extent of the obviousness attack that was before the judge in closing. And there was no suggestion when the judgment was handed down that the judge had got this somehow wrong. You've overlooked our challenge to claim 3 over Neuenschwander. There was no suggestion because there was no challenge. It had gone. So that's why that's the first admission. But my lords, we say the position actually gets worse in light of what's happened on appeal. Because in paragraph 6 of the original grounds of appeal, the appellants relied on both Neuenschwander and Salati. Now, given that there was no contest that claim 3 couldn't survive over Salati, that meant claim 3 was alive on this appeal through the conduit of the Salati appeal. But that was abandoned on appeal as well, when they amended their grounds of appeal to drop Salati. And therefore, that was another incident of an admission that claim 3 was valid. There was nothing before the court in the way of a live dispute in relation to Neuenschwander and claim 3. So for those reasons, we say there have been 2 rounds of admissions in relation to these matters. But the other thing, of course, to keep in mind is that the position on the evidence all went one way. My learned friend's decision not to challenge Professor Wheeler's evidence that the skilled person would not have discarded the core teaching of Neuenschwander is determinative on this issue, particularly when you take it together with his not having put his positive case on FMEA. And the position on appeal, of course, was confirmed not just by the grounds of appeal, which said nothing about claim 3, but by the appeal skeleton, which also said nothing about claim 3. Now, pausing there, it was entirely right and proper for my clients, considering in May of this year what was the risk that was associated with this appeal, to say, well, it's not too bad, actually, because it's valid and infringed whatever happens. They haven't got a case on appeal on claim 3, so we're always going to have an award of damages. The matters at stake are nothing like as significant as my learned friend wants them to be now. Now, why should my clients, having taken comfort from that position, have the rug pulled from under them? Well, that's the procedural history. And I've also explained why this is an application. This involves an application to withdraw admissions, but both in respect of the position in closing at trial and the amendment of the grounds of appeal. Now, the withdrawal of any of these admissions requires the permission of the court and is subject to CPR 14.15 and paragraph 7.2 of the practice direction to part 14. You may be familiar with them. We can turn them up in the white book if you like. But this calls you to examine the following grounds. First, the grounds upon which the applicant seeks to withdraw the admission, including whether or not new evidence has come to light, which was not available at the time the admission was made. Well, there's certainly no new evidence, but there's also no new grounds. They abandoned precisely these grounds before the judge. B, the conduct of the parties, including any conduct which led the party making the admission to do so. This is entirely voluntary, and you have no evidence in relation to that matter either. C, the prejudice that may be caused to any person if the admission is withdrawn. Well, we had the right to have this issue considered and decided by the trial judge, and the appellant's conduct has taken that away from us. They didn't raise it as an issue before the trial judge. They want to do so for the first time on appeal. That is plainly prejudicial to us. D, the prejudice that may be caused to any person if the application is refused. As to that, we say that the appellants made a strategic decision not to advance obviousness submissions against Claim 3 over Neunschwander at trial. And they made a strategic decision to abandon the novelty appeal over Salati. They have identified no prejudice resulting from those decisions in their evidence. And in any event, we say the argument is hopeless on the evidence at trial. E is the stage in the proceedings at which the application to withdraw is made, in particular in relation to the date or period fixed for trial. I think 18 months after the trial might be a record in relation to an application such as this. Certainly it doesn't appear those drafting the rules had anything like this in mind. F is the prospects of success if the admission is withdrawn. I've addressed you on that already. And G is the interests of the administration of justice. As to that, we say it's difficult to see how it can lead to anything other than a refusal of the application. So that's admissions. But even if you allow the admission to allow that application, that hurdle can be passed, it's still a very late amendment. So those would all apply if the application had been made in June of this year. But it wasn't. It was made a week ago. And my learned friends need permission both to withdraw the admission and to make a very late amendment. Of course, in respect of any amendment, the applicant has to show a realistic prospect of success. I've addressed you on that already. But in addition, when one is concerned with a very late amendment, the applicant bears a heavy burden in respect of persuading the court to exercise its discretion. And there are specific evidentiary requirements, and none of which have been addressed in the evidence for this application. That evidence identifies two causes for the application. The first is paragraph 2 of our respondent's appeal skeleton. The second is a letter from my solicitors seeking clarification of their case. As to the former, paragraph 2 of our respondent's skeleton merely pointed out that abandoning the appeal over Salati left Claim 3 without challenge in the prior art. Well, I don't understand that to be in dispute. But the appellant's own abandonment of part of their case cannot then provide them with the basis for bringing a new case. That would make a nonsense of the whole procedure. There must be more than that. As to the letter, well, the evidence on that is we say, unsatisfactory. The letter itself you'll find in Supplemental Bundle 3. Behind tab 29, page 795 of the bundle. My lords, it has nothing whatsoever to do with Claim 3, which is a request for clarification about the appellant's obviousness case in relation to Claim 1, remoteness. In the application notice for this amendment, that is said to be a basis, to provide a basis for the amendment. We say that's a regrettable approach, given the circumstances of the amendment and indeed the admissions that they need to withdraw. We say the court might have expected a degree of humility from the appellants, accompanied by genuine candour as to why they were doing what they were doing at this juncture. Instead, they put before the court an explanation which is difficult to see as anything other than misleading. My lords, this application has already been disruptive and prejudicial, and for these reasons we invite you to dismiss it. But if you do allow it in, you have my submissions on the merits, that on the evidence before the trial judge, Claim 3 must be held valid. Just one point to add on that. My learned friend's case on the invalidity of Claim 3 now seems to be entirely disconnected from the prior art. It's a free-floating attack, but that's not how the law of obviousness works. You don't get to shake off the detail of Neuenschwander just because you have invalidated Claim 1 and Claim 2. You don't get to start from Claim 2 as if it were prior art. The question is still, is Claim 3 obvious over Neuenschwander? And my learned friend made no attempt to advance a legitimate case. You can't just wave at some common general knowledge and say, well, look, it's in the CGK, because the question is it obvious to combine that particular part of the common general knowledge with Neuenschwander? And there's just not a shred of evidence that it was, because the case was never put. My lords, those are our submissions on the amendment, and I was then going to move on to the main substance of the appeal. We identified 9 issues arising on this appeal. I've dealt with the 9th already, and it may be that I'm overcounting by 1 in light of my learned friend's submissions, but just to let you know how I think we're going to take things forward. There are 2 issues of construction of Claim 1, insertion and remoteness. Then there's a related question of insufficiency, which is bound to the insertion construction issue. Then we have novelty of Claim 1, which is dependent on the appellants being right on both construction issues. And then what remains all comes under the heading of obviousness. First, the mindset of the skilled persons. Then we have the technical obviousness issues. As you will have heard, the appellants do not say that full insertion was obvious over Neuenschwander on this appeal. So the Claim 1 obviousness appeal relates only to the remoteness feature. Now we've broken that into issue 6 and issue 7, because it's a rather different question depending on whether your target is narrow remoteness, as per the judge, which requires you to keep socket and supply device apart, or broad remoteness, where they're allowed to be neighbouring each other in the armrest of the seat. But I didn't detect much enthusiasm for the latter in my learned friend's submissions. So it may be that that's fallen away. I will check with him over the adjournment and see if that's the position. And finally, technical obviousness of Claim 2. And subject to having taken the amendment first, that is the order in which I propose to proceed, subject of course to my lords. Now, we also have a number of procedural objections to certain of the obviousness arguments, in particular that they weren't raised properly below. Again, my intention is to explain those where they arise. So we can move to construction, I think, issue 1 and 2. Before getting into the details of the particular wording in issue, it may assist to consider the bigger picture. What is in dispute? What are these devices concerned with? All the devices in issue are intended to mitigate the well-known safety risks associated with mains voltages. And to do this, they all deploy authentication tests. The patent has 2 tests, Quintel has another, and Neunschwander another. But there's a unifying concept, which is that power will not be supplied to the plug until a plug authentication test of one form or another has been passed. And the objective of those tests is to distinguish between genuine plugs on the one hand and inquisitive children with paper clips or knitting needles on the other. So that's the authentication test, but in addition, both the patent and the Quintel prior art deploy a remote arrangement. So you could have authentication without remote, but the remoteness involves the power being kept away from the socket until it's needed, until the authentication test has been passed. My lords, if you could take the patent. We are concerned, of course, with claims 1, 2 and 3, which are on page 7 of the document. The authentication test of claim 1 is based on the expectation that a genuine plug will have 2 contact pins. And you can see that in the final sentence of the characterizing portion of the claim. The supply device only applies the supply voltage to the socket if the presence of 2 contact pins is detected simultaneously. So that's the patent's test. I need to just sound a word of warning in relation to simultaneous. As you'll have seen from the Neunschwander prior art that you've just been shown, simultaneous appears in different contexts, and you need to be careful to distinguish between simultaneous presence and simultaneous arrival. Simultaneous presence is claim 1. Simultaneous arrival, or something akin to it, is claim 2. Claim 1 is talking about simultaneous presence, and as a result, a child armed with a single knitting needle would be unable to achieve electrocution using the claim 1 device. But a pair of knitting needles inserted sequentially into the socket could access mains power. Claim 2 then relies on the further characteristic that a genuine plug is symmetrical. As a result, when it's inserted into the socket, the 2 pins will arrive at almost precisely the same time. And the claim 2 authentication test is for the simultaneous arrival of plug pins. If the arrival of the pins is not substantially simultaneous, you don't get any power. So going back to our inquisitive child, they would need to be remarkably effective in plunging a pair of knitting needles into the socket at the same time in order to obtain an electric shock. Claim 3, as you've seen, is then mechanical switches. I'm not going to deal with remoteness and insertion in precise isolation, because I'm going to take you through some passages in the specification, and in particular paragraph 5, Quintel, and the German court decision, where they're dealt with together, or at least in the same documents. So the parties are agreed that the first relevant passage for the purposes of construction, or the first important passage, is paragraph 5, and that tells you in terms that the introductory clause of claim 1, which includes both the insertion and the remoteness integers, is based on a French patent called Quintel. If you look at paragraph 5, it contains two propositions. The first sentence does. First, that the whole of the introductory clause, claim 1, is based on Quintel. Second, more specifically, it records that Quintel has the remoteness feature. The supply device is arranged away from the socket. The question arises, what does this cross-reference mean for the purposes of the disputes before this court? As to that, we say the judge got it entirely correct. If you're in any doubt, it tells you to go to Quintel. Now, Lord Justice Jacob considered a very similar type of cross-reference in the Virgin Construction case, which is in the authorities bundle at tab 2. Perhaps we could just turn that up. And if you could turn forward, please, to paragraph 21. Well, just to give you the context, paragraph 20, the submission from Mr. Mead, who wanted to rely on the cross-reference, was that when the skilled man sees a pre-characterizing clause, he will strongly incline to the view that the skilled man saw that as being old, and that inclination will be reinforced where the clause is clearly said by the patentee to be based on prior art, which he specifically acknowledges. And that contention was accepted, even without the two-part claim structure, because the skilled reader knows that the patentee is trying to claim something which he considers to be new. He will be strongly averse to ascribe to the claim a meaning which covers that which the patentee acknowledges is old. And if the patentee not only acknowledges that a particular prior art is old, but then has a pre-characterizing clause which is fairly obviously based on it, the skilled reader will be even more strongly inclined to read that clause as intended to describe that old art. Well, our position is stronger still. It's not that it's fairly obviously based on it. We are told in terms that it is based on it. So I'm going to invite you to follow the direction in paragraph 5 and take up Quintel and consider what it tells us about the construction issues that are before this court. Quintel is in the supplemental bundle, the first supplemental bundle. Behind tab 4.
I assume we're doing all right for time, so I was proposing that we stopped at about 4:15.
Very good, my lord. If we could pick it up, please, on page 2 of Quintel itself. One has to be careful with Quintel's numbering because there are 2 page 2s at the top of the document, but I think it's page 30 of the bundle. The paragraph at line 5 addresses safety concerns with young children and electric power. And then at line 16, there's a concern about the quality of mechanical contact between socket and plug pins. Then you have the first object of Quintel introduced at line 26. A first object of the invention is an electrical safety socket which can only allow the electric current to flow when the plug is properly inserted in the socket, so that the contact surface between the pins and the corresponding outlets is maximum, which reduces the unwanted resistances. That is a reference back to the degrading quality of electrical contact that you see at line 21 to 23. Now, the appellant's expert, Mr. Borowski, confirmed that which you might suspect, which is that maximum contact of the surface between the pins and the corresponding outlets, sockets, would occur when the plug was fully inserted. So you've got properly inserted, which we say means fully inserted, and then the maximum contact, that's just doubling up. Now, that is important, we say, because the appellant's answer to Mr. Borowski's evidence about proper insertion, which is problematic for them, is to suggest that there's a significant difference between properly inserted and fully inserted. And we say that that's doesn't work as a matter of language. No one would say in this context, in the context of safety, no one would say that a plug that was half in was properly inserted. And there's one little element of the prior art of the CGK to bear in mind in relation to that, and that is that for our plugs in the United Kingdom, it's accepted that they have a very high safety rating. They're big, solid, you can't push them in the wrong way. They also have sleeves around the live and the neutral pins, which means by the time the plug gets half in, so as to touch the electrical contacts of the socket, you couldn't actually touch, you couldn't reach the electrical current because of the sleeves, the black non-conductive sleeves that are around those pins. But that doesn't happen in the US, it doesn't happen in the EU. Those sleeves are very much a United Kingdom thing. So without those sleeves, it becomes all the more important to ensure that your plug is up to the hilt. If you're concerned about children playing with electricity, the plug needs to be up to the hilt so that those pins, live pins, are not exposed. And then we have the second object of the invention at line 33, which is a socket which makes it possible to establish a watertight contact even underwater without the risk of short-circuiting. And again, Mr. Borowski accepted that this described an arrangement where the plug and socket were brought together so as to abut each other, thus making a seal. And the body of the document, as you would expect, reflects these objectives. If you turn forward, please, to page 36 of the bundle. You'll see the socket labelled B, and it's located at a distance from the supply device, which is 4 at the top of the page, which Quintel calls the housing. And note, please, the discontinuity in the cables that are connecting. So 5, 6, 10, 11, those are 2 signal cables and 2 power cables. And the discontinuity indicates that these are properly kept away from each other. And the socket has a switch 2, which cooperates with the magnet 1 that is on plug A in the bottom left. And when the plug is fully inserted, the switch causes the relay, which you see at the top, 7, to close, and mains power is then supplied. The full insertion, which was described as the first part of the first object of the invention. Sorry, I'm going to go back to the text then, and I wonder if, given the time, that's a convenient moment.
Yes, thank you. So 10:30 tomorrow. Thank you.
All right.